Hello, everyone. Thank you for joining me today. The purpose of today's presentation is to discuss employment-based options, employment-based green card options for those with Daca. My name is Beata Leah. I'm a partner at Minsky, McCormick & Halligan, an immigration law firm here in Chicago. And I've been practicing primarily employment-based immigration since 2007. I'm presently working on several cases where a Daca recipient is being sponsored for an employment-based green card. And I wanted to share information about the process with you today. Unfortunately, as many of you know, the U.S. Supreme Court is currently considering whether or not to cancel Daca, and a decision is expected in the spring or early summer this year. Furthermore, what's unfortunate is that many of you who have likely gone to nonprofits or other immigration attorneys for an opinion on what your options are in lieu of the fact that the Supreme Court is expected to cancel Daca, or the possibility that it will cancel Daca or phase out Daca, we're possibly not advised about options to get a green card through your employer, because unfortunately most nonprofits have no experience in employment-based immigration, and many other immigration lawyers also have no experience in employment-based immigration. And so many of you may in fact be eligible for a green card through an employer but may not be aware. And so that is the purpose of our presentation today. Although it is true that many Daca recipients will not be eligible because of the way that our laws are written, a portion of Daca recipients will in fact be eligible for a green card through their employers. And again, the purpose of today's session is to go over the categories of Daca recipients who may be able to benefit from an employment-based green card and what they should do next. Please note, however, that what I say today cannot be construed as legal advice and is being provided for information purposes only. I strongly encourage anyone who is in fact interested in determining whether they are eligible for an employment-based green card to review the individual facts with a qualified immigration attorney and make sure that they are in fact eligible before proceeding further. So, before we go into the categories of individuals who are eligible for a green card through their employer, I want to first discuss why a lot of Daca recipients will simply not be able to benefit from an employment-based green card. Unfortunately, the way that our laws have been written, there are vast categories of people who simply are not eligible for any green card, and in this case, again, specifically an employment-based green card. The Immigration and Nationality Act sets up a set of laws that govern which individuals can qualify for a green card and other immigration benefits in the United States. It creates a system where certain individuals can apply for a green card in the United States, known as adjustment of status. And this is considered a benefit to be able to adjust a person's status and obtain a green card while physically in the United States without having to depart the United States. The Immigration and Nationality Act also creates a separate system for individuals who are not eligible for this benefit of getting their green card in the United States, and creates a process where those individuals have to leave the country and consular process their cases at a consulate abroad, typically in their country of birth. Now, I say that many Daca recipients will simply not be able to benefit from employment-based green card because the Immigration and Nationality Act creates certain rules about who is eligible to adjust their status in the U.S. And it prohibits individuals to apply for an adjustment of status if they had accepted unauthorized employment prior to filing the adjustment of status application, or if they've been in unlawful immigration status prior to filing the application, or for those who have failed to continuously maintain lawful status in the United States since their last admission. Now, while there is an exception to this rule, the exception typically does not apply to Daca recipients. The exception allows or forgives up to 180 days of unauthorized employment or failure to maintain status since their lawful admission. But again, most Daca recipients will not be eligible for this exception because Daca itself is not a status, and many Daca recipients do not have a lawful admission. In fact, most Daca recipients came into the United States without inspection, or IWI for short, as children, and for those who did enter on a visa, for example, most of them would have been without a status for more than 180 days. So again, many Daca recipients will not be able to benefit from an adjustment of status application filed by an employer in the United States because of the way that our immigration laws are written. However, there is also this process of going to the consulate. And in fact, the problem with going to the consulate is that many DACA recipients will also have a problem with proceeding with their case abroad. The reason is the Immigration and Nationality Act also creates certain restrictions on who can depart the United States and then return after consular processing their case at the consulate abroad. And this is commonly known as the 3 or 10-year bar. The laws are written in a way where an individual who has accrued more than 6 months but less than 1 year of unlawful presence after they turned 18 years old and then departs the United States triggers a 3-year bar on returning to the United States. And those individuals who have accrued more than 1 year of unlawful presence after they turned 18 and depart the United States to consular process their green card cannot return for a period of 10 years. So again, depending on the amount of time that a person has been unlawfully present in the United States after their 18th birthday, if they depart the United States to pursue an employment-based green card at the consulate, they may have triggered a 3 or 10-year bar and cannot return to the United States for that period of time. So again, in summary, many DACA recipients are not eligible to either file for their green card in the United States through an adjustment of status application, but they also cannot leave the United States to pursue a green card at the consulate, because if they do, they will trigger a 3 or 10-year bar on returning to the United States. Okay, so that's kind of the big picture and the reason why many DACA recipients will not be eligible. But again, the purpose of our presentation today is to determine who is eligible. And there are, in fact, categories of DACA recipients who will benefit from an employment-based green card. And I've broken this down into 3 main categories of people who should seriously consider pursuing an employment-based green card and talking to their employers about whether or not they would be willing to sponsor them for a green card. So the first category of people who would be eligible for a green card through an employer are individuals who are considered to be eligible for what's called 245I. 245I is a section of the Immigration and Nationality Act, again, the set of laws that describe who can qualify for various immigration benefits. And 245I says that certain individuals can nevertheless pursue their green card application in the United States and file an adjustment of status, even if they entered without inspection, even if they've worked without authorization, even if they've never had lawful status, regardless of how long they've been in the United States unlawfully, and regardless of how much unlawful status they've gained, if someone, an employer or a family member, had sponsored either them, their spouse, or their parents for a green card by April 30th, 2001. So if someone had sponsored you, again, your spouse or your parent, for a green card by April 30th, 2001, you have possibly other options, including the employment-based green card. Now, considering the age of most DACA recipients, it's highly unlikely that anyone would have sponsored them, a family member or an employer, by April 30th, 2001, because again, most of the DACA recipients are in fact either born shortly before that date or shortly after that date. However, it's possible that someone would have sponsored their parents. And this is where it's really important to talk to your parents about their immigration history and find out if perhaps a U.S. citizen aunt or uncle would have sponsored them, or a permanent resident or U.S. citizen parent, meaning your grandparent, would have sponsored them, or even an employer. It was very common in the late 90s and the early 2000s for employers to sponsor workers for permanent residency. And you may not be aware that your parents actually make you eligible for this benefit, because by having someone having sponsored your parents, for example, you can now use that to qualify for an employment-based green card. Now, there are other requirements to being eligible for 245I, such as the filing of the application that occurred before April 30th, 2001 must have been properly filed and approvable when filed. And in the event that the person is eligible, they have to be willing to pay an extra fee, a penalty of $1,000. But again, the key question here is to find out the full immigration history of your spouse and your parents to determine if someone had sponsored them by April 30th, 2001, making you possibly eligible to use 245I and pursue a variety of green card options, including through an employer in the United States without departing the country, without triggering a 3 or 10-year bar, and without having to worry about any waivers. Okay, so again, the first category of people who are eligible to consider employment-based green card options with DACA are those who are eligible for 245I. All right, let's go on to the second group of people who may be eligible. These are the individuals who have less than 6 months of unlawful presence after they turned 18, and these individuals will not need a waiver to consular process their cases. So we're moving on to a group of people who will unfortunately not be able to pursue an adjustment of status in the United States because, again, they are not eligible for 245I. No one sponsored their parents or their spouses by April 30th, 2001, but that doesn't mean that they're not able to move forward. If you obtained DACA before you turned 18 and a half and you've continually renewed your DACA without having any long gaps in between your DACA renewals, it's possible that you don't have 6 months of unlawful presence. Again, the Immigration and Nationality Act says that unlawful presence only starts when a person turns 18. So, and again, another section of the Immigration and Nationality Act says that the 3-year bar begins for those who accrued more than 6 months of unlawful presence in the United States after they turn 18. So again, if you obtain DACA before you turn 18 and a half and you've been renewing it, you will likely not have 6 months of unlawful presence, and you would potentially be able to consular process your case, depart the United States, attend your interview at the consulate abroad in typically your country of birth without needing a waiver. Now, you want to note that, again, gaps in DACA renewals will count as unlawful presence. So if you obtained your first DACA when you were 16 or 17, and then for whatever reason you didn't renew it on time, maybe you didn't have the money to renew it timely, and there is a long gap between your DACA renewals, you want to count every single day between your DACA approvals to determine that you have less than 6 months. The other caveat is that because the Supreme Court is expected to potentially either cancel or phase out DACA in the spring or early summer, it's possible that going forward, you may have to be aware, you may have to count additional unlawful presence that may happen in the future, making you, again, ineligible to pursue consular processing. But assuming DACA is phased out slowly and you start the employment-based green card process quickly, if in fact you still have less than 6 months, it is possible, again, to depart the United States and consular process your case without a waiver. Now, the other group of people who will also not have accrued 6 months or more after their 18th birthday are those who first came to the United States on an F or J visa. So again, I said earlier that most DACA recipients were brought by their parents into the United States unlawfully, crossing the border without any visa or status, but many did come on a visa and simply overstay that visa. So if that visa was an F visa or a J visa, typically as the child of a student or an exchange visitor, then those individuals were admitted into the United States for what's called duration of status without a set expiration date. And those individuals are not accruing unlawful presence regardless of how much time has gone by since they've been in school, since their parents have been in school, since they were participating in their J1 program. And again, they're not accruing any unlawful presence. This is assuming, though, that they haven't since changed their status. So in some cases, the person came on an F or a J and then changed their status to something that did have a definitive expiration date, and so that would change the circumstance. But again, assuming someone came on an F or a J and did not change their status, except for the filing of a DACA, they are probably not accruing unlawful presence and, again, can consular process their case at the consulate without needing a waiver. Okay, so again, in summary, for those individuals who cannot pursue an adjustment of status in the United States, but who have accrued less than 6 months of unlawful presence after they turned 18, typically DACA recipients who got it before they turned 18 and have renewed it timely ever since, those individuals may not have 6 months of unlawful presence and can consular process their cases without a waiver, including through an employer. All right. Now let's go to the third and final category of people who are eligible for an employment-based green card if they have DACA. Those are people who, again, are not eligible to adjust their status in the United States and probably accrued more than 6 months of unlawful presence after they turned 18, but they have a qualifying relative for a waiver. So many people are familiar with the process of getting a green card through a U.S. citizen spouse. But you can pursue a similar green card process through an employer if you have a qualifying relative for a waiver. So what does that mean? Again, these are people who have more than 6 months after they turned 18 of unlawful presence. Perhaps they got their first Daca when they were 19, 20, 21, and they have more than the 6 months. If they have certain relatives in the United States, they may be able to pursue an employment-based green card option, but use that relationship with that qualifying relative for purposes of filing a waiver and waiving that 3 or 10-year bar before they depart the U.S. for their consular interview. So the Immigration and Nationality Act allows you to waive your 3 or 10-year bar if you have a U.S. citizen or permanent resident parent or U.S. citizen or permanent resident spouse. Practically speaking, if you have a Daca recipient who has a U.S. citizen spouse, it's unlikely that they're going to pursue an employment-based green card option because the marriage-based option is typically faster. But if you have a permanent resident spouse or a U.S. citizen parent or a U.S. citizen or a permanent resident parent, that is, again, so U.S. citizen or permanent resident parent or permanent resident spouse, while those family members can technically sponsor you, there is a backlog on those green cards, and the processing time for those green cards can take many years and sometimes decades, whereas the employment-based green card option is significantly faster. In most cases, depending on your country of birth and depending on the process and how it's handled, the employment-based green card process can take, let's say, 1.5 to maybe 3 years, assuming there are no hitches or issues, which again is typically significantly faster than for individuals who have been sponsored by a permanent resident or U.S. citizen parent or a permanent resident spouse. And so again, in this case, if you have that qualifying family member, U.S. citizen, permanent resident parent, or permanent resident spouse, you can initiate the process through an employer and then use that qualifying relative to waive the 3 or 10-year bar before you leave the country and come back to the United States after the waiver you would leave the United States after the waiver was approved and come back to the United States after your consular interview without any issues. All right, so again, in summary, the 3 main categories of people who should consider an employment-based green card option, who should meet with an attorney to determine if they are in fact eligible, and then should approach their employers to ask them to sponsor them for a green card, are individuals who are eligible for 245I because a family member or an employer sponsored them, their spouse, or their parents by April 30th, 2001, or those individuals who have Daca and have not accrued more than 6 months of unlawful presence since they turned 18, likely because they got their first Daca approval before they turned 18 and a half, or those who entered on a J or an F visa and have not changed their status since. And finally, the third group are those who have a U.S. citizen, permanent resident parent, or a U.S. citizen or permanent resident spouse, making them eligible for a waiver, which would be filed before they consular process their case, to waive their 3 or 10-year bar. Now, if you think you're eligible, I recommend taking the following next steps. First, compile all of your immigration records and all of the immigration records of your spouse or your parent, particularly if you think that that makes you eligible for 245I. You also want to collect information regarding your entries and exits in and out of the United States, and then take all of that information and documentation and consult with an immigration attorney, particularly one who handles employment-based immigration. Then, if it's deemed that you're eligible, approach your employer to discuss their willingness to sponsor you for a green card, particularly in light of the fact that the Supreme Court is weighing whether or not to cancel Daca, and a decision is expected as early as this spring or summer. If you're a valuable employee, they may consider it. Tell them that almost any employer can sponsor someone for a green card and in almost any position. In fact, right now I'm working on cases for a construction worker, a paralegal, and a dental hygienist. There is no requirement that the person being sponsored be working in a position with a bachelor's degree, a master's degree, or any kind of specific requirement. The process is based on the employer's need. The main question for the employer to ask is, How difficult would it be to fill your position with a U.S. worker, a permanent resident or a citizen, if you left your job? Many employers have a hard time filling a job because of the unique set of skills needed to complete that job. Or some employers are located in an area or in an industry that is simply very difficult to fill employees in that area or in that industry. So again, this is the initial conversation you want to have with your employer to find out if they would be willing to even entertain a conversation about sponsoring you for a green card. And then, if they are interested, join me on January 24th, 2020 at noon, just like today, where I'm going to go over the details of the employment-based green card process. I'm going to discuss the employer's costs and the employer's obligations throughout the process and answer their questions so that they can feel more at ease about considering this option for you. If you still have questions about whether or not you're eligible or if you'd like to schedule a consultation with me, you can email me at bleja@mmhpc.com or call our office at 312-427-6163. Thank you for your time, and I hope you got something out of this today. Thank you.